Let's take this conversation further with Mbekezeli Benjamin, who's a research and advocacy officer at Judges Matter. He joins us now. Mbekezeli, good evening. Thank you so much for your time. Really do appreciate it. My first question will have to be an incredibly rudimentary question, but I think it's necessary for us to ask that question because I think we take for granted that we know what these things mean all the time. What we heard a lot today are descriptors and a compendium of the term the criminal justice system. Now, the criminal justice system, I understand to be a collective of institutions and processes of various parts of the state. It doesn't just mean one thing. And we often use it interchangeably, it seems, to mean one or the other of the institutions that make up this thing, and never quite exactly just the collective. Describe to us, when we speak of the criminal justice system, what are the actors and institutions that we're talking about?
Good evening, Oliver, and good evening to the viewers. Usually when we refer to the criminal justice system, we usually refer to those institutions of the state that are set up to detect, to combat, to prosecute, and to punish people for crime. And most of those institutions fall within Chapter 8 of the Constitution. So those institutions would include, for example, the South African Police Service, the National Prosecuting Authority, the judiciary in the form of the lower courts, the magistrates' courts, the superior courts, and I mean, you can also include the correctional services as part of the broader criminal justice value chain. But the crucial ones really are the police, the prosecuting service, and the courts. Those are really the key fundamental institutions in the criminal justice system.
Yeah, how interdependent are the police, the prosecuting authorities, and the judiciary upon each other in the execution of the work of criminal justice?
Well, they're extremely interdependent. It's not possible for each of or any of those institutions to do their job without the other. You can't prosecute without police having done their investigations. You can't convict anyone or you can't try anyone for a crime unless the prosecution brings that trial and that prosecution. And so it is basically one value chain of institutions, and they are really set up to deal with crime, because as soon as a crime is committed anywhere in the country, it is primarily the responsibility of the South African Police Service to do those investigations and prepare the dockets. Once the dockets are ready, they are referred to a prosecutor who will assess the docket and whether there is enough evidence that show a crime. If there is enough evidence, then they enroll that docket in the court as a form of a formal charge, and then the person is prosecuted. And depending on the evidence, again, depending on the quality of the investigation and the prosecution, it is then that the court can come to an outcome, whether it's guilty or not.
Yeah. Now let's talk about the statement and the opening statement we heard there from the chief evidence leader this morning, Advocate Terry Mutau, outlining exactly how they'll follow the work that they'll be doing and why that was so important. Of course, that statement is important for setting the tone and the context because it has to reflect a consistency with the Commissions Act of South Africa. Did you sense anything that could potentially present as a difficulty to the Commission in the outline of Advocate Mutau's order of plan?
Well, look, there were two important statements that came from the chairperson of the Commission, Justice Madlanga, first and foremost, who explained the purpose of this Commission of Inquiry, which is to investigate the very serious allegations that were made by General Mkhwanazi, and the fact that if there needs to be a thorough investigation first and foremost, but if there is credibility to the allegations, then it will spell trouble or doom for our criminal justice system. I think that was important in setting the tone. But secondly, the opening statement by the evidence leader also provided useful insight on the parameters of this investigation and the commission itself, because yes, it is guided by the president's terms of reference, which he does so via the Constitution, Section 84, but also the Commissions Act. But there were many points in which Advocate Mutau explained that during the course of the investigation, they will uncover certain information. It doesn't mean that they've already taken a view, but it is meant to guide how the process will unfold in terms of the investigation itself and the proceedings before the Commission. The other thing that he kept mentioning was reference to Section 5 of the Commissions Act, which makes it a crime to interfere with the investigations of a commission of inquiry. And I think he was emphasizing that point because the institutions that are investigated in this commission include the police, parts of the intelligence services, the Metro Police, the prosecution authorities, the courts even. And so those are very powerful institutions. So it needed to be emphasized that that investigation must continue without hindrance. And I think that was important to set up front.
Now, today there seems to have been an emphasis on General Mkwanga's leading evidence. And of course, that gave us a sense of where the Commission draw its lines on what it considers to constitute evidence or non-evidence and perhaps just conjecture. I think the word conjecture was used several times by the evidence leader there in relation to General Mkwanga's opening statement pertaining to Minister Senzo Mchunu and whether or not he has a relationship with what is dubbed the underworld there. But repeatedly, General Mkwanga said his opening statement was a reflection of the collective. Now, in an ordinary court of law, I would assume that would present a difficulty, but the Commission has a little bit of flexibility around that. In what ways can it navigate what is considered to be collective evidence or hearsay evidence, so to speak?
Yeah, so that's one of the key differences between a court of law and a commission of inquiry. I mean, a court of law, there are very strict rules of evidence and what can be admitted and what cannot be admitted as evidence in a court trial. But for a commission of inquiry, there's a level of flexibility. And that is because the commission itself is quite inquisitorial. So it relaxes the rules of evidence. And in fact, what Justice Madlanga reminded all of us to say is that the rules of court and the rules of evidence don't ordinarily apply. And so when you hear statements like we or there was a collective that deposed to a statement, that kind of thing wouldn't be allowed in a normal court trial because you can only testify on evidence you have personal knowledge of. But what General Mkwangazi, for example, was explaining is that the collective was working on a statement and there was certain information or certain pieces of information that were provided to him, and he wasn't necessarily the one who was directly knowledgeable about that information. So it does show that the Commission will accept certain of that kind of hearsay evidence, but later on, of course, I think it will be corroborated. But there's a level of flexibility that allows a Commission to quickly get to the bottom of what it is in investigating and surface some of the facts and evidence that are needed for certain other institutions, like the Judicial Service Commission, for example, to take action.
Yeah, Mbekezeli, thank you so much for your time. Thank you so much for your insights. Always a pleasure talking to you. Mbekezeli Benjamin coming to us there from Judges Matter.